Good morning and welcome to this edition of the Landlord Law Firm's Landlord Advocate video newsletter. I'm Robert Chesson. In this, our final edition of the 2016 volume of the video newsletter, we're going to take a break from our Fair Housing series and talk about a very important aspect of the legal process in the courthouse that has come up in various conversations over the last several months. That issue is the issue of obtaining default judgment when a tenant fails to appear in the courthouse. So first, let me set the stage. You've referred a case to your landlord attorney. They've filed a notice to quit. They've brought the case to the courthouse. And right now, the tenant has not decided to participate in the court process and actually appear in court to defend the action. In most instances, your landlord attorney is going to obtain a default judgment and perhaps an execution if necessary in order to finish the case for you in an expeditious fashion. The process of obtaining that default judgment, however, is a place where your case can get stuck and perhaps can't be unstuck without a whole lot of time and effort. Federal law requires for the moving party, that would be you in this instance, to show that the defendant who has not appeared in the case is not in the military service. This is done by supplying what's often referred to as a military affidavit. Most of you have heard of those and supply those on a regular basis. Where we don't have birth dates and social security numbers, obtaining those military affidavits becomes quite challenging. It could take the marshal days to track down somebody who can supply that information. It may take them weeks to actually get in contact with the tenant so that the tenant can actually provide the information that they're not in the military service. Remember, without that information, the court won't give you the default judgment that we're looking for. The simplest and easiest solution to this scenario is to obtain social security numbers and dates of birth. Keep those properly secured in your files, and if you ever have to bring that resident to court, supply that to your landlord attorney so that they can get the default that you're looking for when the tenant doesn't participate in the process. This will speed up the entire court process, not only when you can't obtain a default, but when you're just simply trying to force the case forward so that the tenant will participate and you can get the case resolved on some sort of agreement. Since most of you are collecting this data when you're screening your residents, you've already got it. If you don't, start collecting it. If you're not sure how to do that or how to keep it secure, please reach out to your landlord attorney so they can help give you good advice on handling that information. Thank you for joining us for this last edition in 2016 of the Landlord Advocate video newsletter. I'm Robert Chesson.